Welcome back to the Crazy Left Coast. In this one, we're going to talk about the major changes to CCW laws in the state of California. This is going to go into effect January 1st of 2024. This is also known as Senate Bill 2, SB 2. And I'm going to be making reference to Penal Code sections. But if we're going to Penal Code 26-162, and again, Senate Bill changes statutes. Prior to the issuance of a license, renewal of a license, or amendment to a license, each licensing authority with direct access to the designated Department of Justice system shall determine if the applicant is the recorded owner of the particular pistol, revolver, or other firearms. What does this mean? Well, the way the current law read is that, let's say this firearm is in your wife's name. You're married. That is deemed community property. You could put that one particular firearm on your CCW application of approved guns to carry. The new law is saying, no, you got to put it in your name. Going on to Penal Code Section 26165A, for the new license applications, there's a lot of changes. For a new license application, the course is going to be 16 hours, and there's going to be a written test at the end of that course. Under the current law, the course was 8 hours and there was no written test. You wanted to learn, take your notes, and learn the laws. It was being explained to you. But now the government's saying we want you to take a test. My personal opinion is that all these laws are designed to make it hard for someone, a good law-abiding stand-up citizen, to get a CCW permit. Section 26-200 of the Penal Code goes into what you can't do or where you can't be with a CCW firearm. A licensee shall not do any of the following. This is 26-200A1. Consume an alcoholic beverage or controlled substance as described in Section 11053 to 11058 of the Health and Safety Code. So those sections talk about what is the definition of alcohol and what are controlled substances. And it's still current law. Don't have your gun while you're drunk or consuming alcohol or under the influence of any type of medication. But here's a change. A2, be in a place having a primary purpose of dispensing alcoholic beverages for on-site consumption. That is going to be a subjective call, because now you've going to a restaurant, and let's just say you're going to what's called BJ's restaurant. That's a chain of foods. And you go to BJ's, and let's say that there's a bar there, and it's a small bar, but they have a restaurant. Well, it looks like the primary purpose is to serve food, but let's say that their bar makes them all the revenue. Then it could be argued the primary purpose is to sell alcohol and make revenue from the alcohol. Arguably, if there's some issue there and you're contacted because you have your CCW on you, then theoretically under 26-200, you would be in violation for being in that place because of the primary purpose. Going on to A4, carrying a firearm not listed on the license or firearm for which they are not the recorded owner. I just went over that, so that was a major change. Also, now it's a violation if you fail to carry your license on you. That's A7. It's also a violation of the law, A12, if you refuse to display the license or to provide the firearm to a peace officer upon demand for purposes of inspecting the firearm. Which means if you're coming in contact with law enforcement, it could be a simple traffic stop. You identify, you declare that your weapon's on you. He says, hey, let me see your license. Here you go. Let me see your gun. Please take it out of my jacket or whatever you have it. He verifies that the serial number on the firearm matches the serial number on your CCW. You're good to go. Why does this have to be stated? Because on YouTube, TikTok, you've seen where some angry people with CCWs are giving the police officers a hard time when they want to inspect the weapon. Now, Section D said a license authorized to carry a firearm pursuant to this chapter shall not carry more than 2 firearms under the licensee's control at one time. That's saying that you can't have more than 2 guns on you. That's self-explanatory. Going on to Penal Code 26.210, when a licensee under the chapter has a change of address, the license shall be amended to reflect the new address, and a new license shall be issued pursuant to subdivision B of 26.215. If the license is one to carry loaded and exposed pistol, revolver, or other firearms. I'm going to say that might be like a security guard license, which capable of being concealed. Again, all handguns can be concealed upon the person. The license shall be revoked immediately upon a change of the licensee's place of residence to another county. It's saying if you move, boom, under this county, you had a CCW, you moved to a different county, boom, they're going to take it away from you. You just don't have it. If that's your planned move, you might want to apply for a new license in your new county. And then Section 27, which is Penal Code 26.230, describes the locations where a person can and cannot take up a CCW license firearm. A person granted a license to carry a pistol, revolver, or other firearms capable of being concealed upon the person pursuant to shall not carry a firearm on or into any of the following. And this is where you could call, people have been using the word sensitive places, but there's a laundry list of places that you theoretically you could be charged with a criminal crime if you're in one of these locations. Number 2, a building, real property under the control of a preschool or child care facility, including a room or portion of a building under the control of a preschool or child care facility. So they're just saying you can't have your CCW on your person if you're in a preschool or child care facility. Also, a building, a parking area, and this is where it starts getting real tricky. A building, parking area, or portion of a building under the control of an office of the executive or legislative branch. Can't go on to government controlled. There was a federal law that talked about federal state parks. The case basically said you can't take your CCW into the building, but you could have it while in the park. I forgot the name of the case, but I have to look it up. I'll put it on another video. A building designated for court proceedings, that would be your courthouses and the parking lots. Any type of building or parking lot that is under the control of a juvenile detention center. A building or parking lot under the control of a public or private hospital. A bus, train, or other form of transportation location or the parking lot. A building, parking lot under the control of a vendor or establishment where intoxicating liquor is sold for consumption on the premises. I think that one's going to get a lot of people in trouble. So that means if you're going to the National Orange Show, the farmers market, and you're in the parking lot, theoretically you would be in violation. A public gathering or special event conducted on real property open to the public that requires the issuance of a permit from a federal, state, or local government. That means any type of fair, farmers market where there's a permit, or a private party, private, let's say a music event that is on it would be anything. If they're issuing a federal, state, or local government permit, then yes, if you're in that area or on the parking lot, you're in violation. A playground or public or private use center as defined under 626.95. A street or sidewalk adjacent to a playground or youth center. A park, athletic area, or athletic facility that is open to the public and on a street or sidewalk. Real property under the control of the Department of Fish and Game, that would be their building. Any area under the control of a public or private community college or university, including but not limited to buildings, classrooms, laboratories, medical clinic. A building, real property, parking that would be used for gambling, gaming, casinos, horse racing. A building, real property under the control of a public library. A building, real property, or parking under the control of airport. Theoretically, if you were driving through a parking lot, you would be in violation of these penal codes. I got a real interesting story on a case we're working on. Let's say Johnny is out in the wilderness hunting. He comes off a ridge and he's going to change hunting location. He puts his gun in the gun rack, drives around a quarter of a mile to go up a different ridge, and in the meantime he gets stopped by Fish and Game. Question is he going to be in violation of a penal code section for having a loaded weapon on a dirt road out in the middle of the wilderness? And yes, there's a penal code, wildlife code that deals with that. A street or driveway, parking area, building or facility owned or leased, controlled by a nuclear energy storage. And if you go back, even sidewalk, a church, synagogue, mosque, or other place of worship. Now you're thinking, all right, what can you do? A financial institution or parking lot, a police, sheriff, or highway, a polling place. Again, not just going into the building, but being in the parking lot. Now, there's a way to comply with these laws, and that would be to have a safety gun-approved lock box in your car or vehicle that you could put your CCW firearm into before you theoretically went into a driveway or a parking lot of one of these facilities. And when you get down to the end of this penal code section, transporting a concealed firearm in the immediate area of surroundings of the vehicle within a prohibited parking lot only for the limited purpose of storing or retrieving a firearm within a lockbox in the vehicle's trunk or other place inside. So they're saying that that's an exception. So if you have the lockbox, let's say you have your CCW and you're going to court to pay a traffic ticket, you ain't taking your weapon inside the courthouse, you put it in your lockbox, and that would not be a violation. It means you could drive into the parking lot, put your CCW weapon into your lockbox, go take care of your business, come out, get it, and put it back on you. All right. I hope this has helped you understand the ramification and the problems that SB2 is going to have with what they call sensitive places, because theoretically everything I just read means you cannot go anywhere outside of your home with a CCW and not be in violation of a penal code unless you have a lockbox with you and you put your CCW weapon inside the lockbox upon entering the parking lot. Again, this is Patrick, the attorney. Have a great day.